many times people perceive in this otherwise complicated environment that child support is set, which it's not, and that property division will be 50-50. But as we've already talked about, 50-50 of what? That's the question. But wrongfully, people get caught up and try to simplify those two previous issues and leave alimony as the battleground. Let's go over alimony just briefly. There are 4 types of alimony: transitional alimony, rehabilitative alimony, in solito, which is a form of property division, or also called lump sum alimony, and then in futuro, or also called periodic alimony. We're not going to spend any time today going into all of the different variations, but we're going to cover some of the broad topics that make these decisions very important. First of all, with alimony, right off the bat, the main consideration is how much. How much and how long is the alimony going to be paid? Most often, that is a function of need and ability to pay. What is one party's needs? What is the other party's ability to pay? Next, we'll look at modifiability. Of the 4 types of alimony, transitional alimony and alimony in solito are the 2 that are non-modifiable. That means that neither party can petition the court to change the amount of alimony awarded and for the length of term that it was awarded. Whereas rehabilitative alimony and alimony in futuro are modifiable. Very, very important in 2006 to many parties to have the divorce over with when it's over with. And where we see it most often is the parties that are in their mid-50s getting a divorce. One party agrees to pay rehabilitative alimony for 8 years to get the person to where the supported spouse can be receiving Social Security. Not that exciting. It's a pretty obvious figure to pick. But in the middle, what happens if the supported spouse gets cancer? It's no longer able to work, no longer able to be rehabilitated. It can be very, very important for the supported spouse to be able to come back and get a little more help to make that transition to Social Security. Vice versa, the supporting spouse may decide, I don't want the exposure over the next 8 years in case something happens to the supported spouse. And they may be willing to pay a premium in alimony to convert that from a rehabilitative alimony form to transitional, where it's non-modifiable. That can have a big effect in the overall negotiations. Next, termination. Very big issue. Is it to be, does the alimony terminate on the death of the payor or the payee? How about cohabitation with a third party? What about remarriage? Each of the 4 types of alimony have different restrictions placed on them in terms of termination. That in of itself, especially if somebody's likely to get remarried, can be very, very important. Alimony in solito is not going to be terminated because it's more in the nature of property division. So that may be something that becomes very, very important in terms of the negotiation. Also, taxation. As much as 35% of the, if you look at it from an effective tax rate, strike that. If you look at it from a marginal tax rate, you could be looking at 35% of the overall obligation being in addition to the supported spouse. Now, highly unlikely to be 35%, but maybe what, 20% to the supported spouse and a 35% reduction to the supporting spouse. That can be real money if you're looking at $8,000, $10,000, $12,000, $15,000 a month. Very important for the parties in the divorce to get tax advice that's accurate before the settlement negotiations begin. Because that's a lot. The net present value of the difference between what's on paper and what they're going to get net of tax can be very, very material. And it's not unusual for, say, a $3 million estate, party's been married for 20 years, to have a $10,000 a month alimony payout, and it not state in the document itself, in the settlement, whether or not it's deductible or includable, because the lawyers didn't want to deal with it. Very, very important for the CPA to step in and issue an opinion letter. It's a good billing opportunity, but more important than a billing opportunity, it's rock solid needed tax advice to a client who's about to settle a divorce. And it's going to make a big difference in the overall picture of the estate as it's being divided in divorce. Next, we also have bankruptcy. We had new bankruptcy laws go into effect in 2005 that I think pretty much helped supported spouses in the alimony context, making sure that the alimony is non-dischargeable. That obligation will survive bankruptcy. But more importantly, don't forget about the possibility of securitizing the alimony through some form of life insurance. It's a great opportunity, and it's one that's overlooked quite a bit. But when you're looking at a payout of $10,000 a month for 8 years, you're looking at $1 million total cash flow, net present value of what, $800,000. We'll securitize that with a $750,000 life insurance policy. And if there's any extra, allow the spouse whose life is being insured, maybe designate that to one of the children. There are great opportunities for estate planning, tax planning in the divorce process that I'm telling you people just do not take advantage of. Life insurance is one of them. A large part of what I do is not written down in as art. Taking a series of facts, how long were the parties married, what did the husband make, what did the wife make, how many children, what's the child support obligation, putting that in a pot and providing advice to my client, almost making it up. What is an appropriate amount of alimony? Now, I'm not making that up. I'm basing that on having read literally thousands of appellate opinions on alimony and handling hundreds of cases, some which are similar, many which are different, most of which are different. In fact, most cases, what makes alimony so challenging is there is no right answer.